just as a last, you've collected, as you do, I guess, in the course of investigation, quite a number of statements from various persons. Yes, I appreciate that the prosecution will, in the fullness of time, determine whether they are going to be witnesses. My question is, what's the basis on which you call for statements? Why do you approach people to give you statements?
Which statements are those on the vettings?
No, statements generally in your docket. There are a number of statements by different people, witness statements, for lack of a better term. No, just general, it's a general question. You are an investigator, you end up with witness statements, so you decide who to engage to provide you with a statement, correct?
Yes.
And I accept that whether or not they're eventually used in the subsequent trial is neither here nor there. That's a decision by the prosecutor. Yes. My question to you as an investigator, when you decide who to approach to provide a witness statement, what yardstick do you use? Why do you approach her and not me to give you a witness statement during your course of investigation?
Why would you approach a particular person?
Yes, yes.
Because you would approach a particular person or a witness to take a witness statement who has knowledge of a particular matter or something within the investigation that you're conducting to confirm or otherwise with regards. That's why we'll obtain a witness statement.
Would it be correct to say you do so perhaps as well to establish either a certain fact or a certain factual matrix relevant to what you are investigating?
Yes.
Would that be fair? Please refer to file 3, page 789. I want to understand this statement. At 789, is it file 3? Yes, file 3.
File 3.
As part of your many witness statements, I located this particular one, and in the context of the conversation we've just had about your criticism of Major General Khan not being a part of the panel, you confirm that this is the statement of Major General Khan, don't you? It says so at 791 in no uncertain terms, and he has signed.
3789, it's the...
789. You started with 3.
Apologies, it's that time of the day.
I know.
Sorry, Chair. 789. That is the affidavit of Major General Khan.
When you approached him, what fact were you seeking to establish for purposes of your investigation?
When he was approached, it was regarding a letter that was signed that he had his name on the top of it. I just want to see here.
No, I just want to know the facts you were trying to have this witness speak to.
Sorry.
The facts of the matter that you wanted this particular witness to speak to when you approached them for a statement. What were you saying that they should give you a statement on?
It's the statement on a letter that had his name on it, that was found in one of the files.
Okay.
We needed confirmation of this letter because it had his name on it. That is in the same bundle.
Yes, no, I see. It refers to it at 4. So it is that letter.
Yes, 793.
So you wanted him to confirm something about that letter.
Yes.
What about the letter? It's there in the docket. So.
What about the letter?
Yes, what about the letter
Okay.
did you want him to speak to? We know the letter.
Yeah.
The letter is signed by Brigadier Ngube. It reflects under inquiries the name of General Khan and Brigadier Ngube under inquiries. It's there. And I'm not aware of anybody denying its existence. I'm not aware of anybody making issue with the fact that it was signed by Brigadier Ncube. So I'm just trying to understand, when you then approach General Khan
Yes.
about this letter, what about the letter were you trying to establish?
The letter was regarding the vetting.
I know.
Yes. So when you apply for an SMS post, you have to, it's in the application, you have to undergo a vetting process.
No, Colonel, I apologize. There is a letter signed by Brigadier Ncube.
That's correct.
That letter speaks for itself. Yes,
Yes.
I agree, it's regarding vetting issues.
Yes.
You then approach General Khan, whose name is reflected under inquiries on that letter.
Yes.
Regarding the content of that letter.
Yes.
What about that content of that letter did you want him to comment on?
The fact remains, if he was aware of this letter,
Come again?
whether he was aware of this letter,
Yes.
that was the one. And during confirming on this letter, we also interviewed him with regards to the post.
Okay, so it starts with confirming whether he's aware of the letter, and he speaks to that.
Yes.
He takes issue at paragraph 5. He says he has no knowledge of the letter which purports that I was involved in preparing it. And this, of course, he says, because his name is reflected under inquiries, we don't have to go there. It is what it is. So we accept that would then put paid to the inquiry regarding the letter. We are done now. He's giving you a statement.
Yes.
All right? Now,
Sorry, Chair.
yes.
Yeah, it was with regards to the letter that has his name on the top, that purportedly comes from his office, that was drafted by Brigadier Ncube and signed on his behalf.
Yeah.
Because at the bottom it's got he's the head of Counter and Security Intelligence. In the inquiries, it's always put in the inquiries the head of that section, right? And at the bottom of it, it's actually supposed to have his details on it, and Ncube is supposed to sign on behalf of him. But that's immaterial. The fact of the matter is...
No, it is material. It is material because what you say at the bottom of the letter reflects is not what is on the letter. I mean, the letter clearly says section head, unless you say this is a description of General Khan. The letter says section head, personnel security, brigadier section head, personnel security, counter and security intelligence, crime intelligence head office, PC Ncube. What
Yes.
in this is about General Khan? A reader of this letter knows and understands that it was written and signed by Ncube.
Yes, if I can explain it, Commissioner.
Yes,
I mean, I worked with these letters here. When you have somebody's name who's in the inquiries as the head of the office, if General Khan's name is not there, and you have just Brigadier Ncube is there,
Yes.
then she signs off as a section head. But now you've put your head of office in the inquiries there. So it should, at the bottom, it should start with the name of the component head, security and counterintelligence. But this letter here has got Brigadier Ncube's details on the bottom as the section head. So basically, if a letter goes out of your office, it carries the component head's details and you sign on behalf of him. So that's why I'm saying Major General Khan is the senior on that inquiries. So he owns this letter.
No, he doesn't. It's not written by him. This letter
no,
does not. No, hold on. You've made the point that his name should have been at the bottom and it's not there. So why do you say he owns this letter?
No, he didn't write this letter.
Yes, why do you say, because he's in inquiries, he owns this letter? Why do you say that? It doesn't bear his signature.
If that was heard, Commissioner, let me just correct it. And let me get a clear understanding on the letter. There's a senior member in the inquiries. This letter was done by Brigadier Ncube.
Yes.
That.
It doesn't represent anywhere that it was done by General Khan.
This
Can we
letter
agree
was
that?
not-
Can we agree that?
Yes.
Yes.
It was not done by General Khan.
Yes.
But it has his name as inquiries, right, on the front, which is a senior person, right? And so you have a senior person here, Major General Khan and Brigadier Ncube. So in report writing, the head of the office, you got his name there. So at the bottom, you should be signing it on behalf of him. 4.
That's according to what? What according to what prescript are you saying that General Khan's name should have appeared in this letter of confirmation? That's according to what? Of SAPS, not
It's
not what?
SAPS. It's SAPS. This is how we do it.
Where do we find that?
Commissioner,
You would have to refer us to something that we can look up to see that you are correct before we can conclude that something is wrong with this letter.
I will try and look for one of the other police documents that's in this file. I think maybe with General Nkua signed in some places, and then we can see. You may find Major General.
No, we've seen those kind of letters. We've been through enough SEPS documents in this Commission of Inquiry that we've seen letters which have different people signing. You are making a different point. You say something is wrong with this letter because it does not contain where General Khan should have signed. And my question is simply, in terms of what is that required? Where do I go to check and confirm that you are correct indeed when you say this letter should have indicated? I know Ms. Silo is having a different discussion with you, but in answering her, you've raised something. And so my question is, what instrument, whether national instruction, whether policy, whatever, what do I look at to see that what you're saying is wrong with this letter in that it doesn't contain General Khan's details? Where do I find that?
Commissioner, I'm not too sure whereabouts you'll find it in the prescripts and but what I can say to you is because I've been there and how we write it in an official way. When you put my name in the front, if my name is not there, if you put my name on a document, I must be aware of it. That's the first part of it. The second part of it, it has Major General Khan and Brigadier Ngube on it. So what I'm saying is what I'm seeing that is wrong with this letter. And I'm saying, this is Brigadier Ngube, she did this letter, but you put General Khan's name here on the top, who's the senior officer that should have signed off at the bottom. That's what I'm saying. But if his name was not there at all, then he doesn't know, then he's got no business on this letter because she's writing it, she's the inquiries, and she's putting her title at the bottom. That's the message I'm trying to get over.
Thank you.
Thank you.
Thank you, Commissioner. Thanks, Colonel. So by the time we get to paragraph 5 of General Khan's statement, the issue about which you approached him is dealt with. However he deals with it, wrong or right. That would be the end of what you required him for, because you said you approached him regarding this particular letter, correct?
It was for the letter and to interview him with regards to the technical support post, because he has been there in crime intelligence and was there at that time.
What about the post? Did you think he could add?
It's his knowledge and experience in the post as laid out in the affidavit obtained from him. But before we move over onto this and move away from the relevance of the letter, the relevance of this letter is this, that it says that this is the confirmation letter is to officially state that on the 25th of July, the applicant, Ms. D. Makwele, submitted an online application in the South African Police e-vetting system for top security clearance with reference that and that. This letter is incorrect. She could not submit an application on the e-vetting system because you have to have a force number. So that's the relevance.
Now, if I may stop you, I don't take issue with that.
No problem.
That's his view as he has expressed it, right?
Yes.
But I'm saying your engagement regarding the letter ends at this paragraph. He's given you an answer and his views on the letter.
Okay.
So that was the one fact you wanted to establish with him. What was the other fact, if any? You keep referencing other fact that you needed to establish with General Khan. What fact is that?
It's as indicated on my paragraph 6 moving down.
It's not yours, it's General Khan's paragraph 6.
think it's because they are the same.
Exactly, because you copied from General
Yeah,
Khan's
because
affidavit.
it's exactly what you have in your affidavit that you say it's your.
Yes, it's General Khan's statement. Chair, Commissioners, it's that time of the day.
Yes.
It's been a marathon.
Okay, now this is the second half of the General Khan's affidavit. You confirm that from paragraph 6, he's now dealing with the issue you raised in your affidavit when you sought the arrest warrant, to the effect that this is a very critical covert crime intelligence at the second line of paragraph 6. He notes, I also cannot understand why Khumalo invited Major General Gabela to form part of this interviewing panel as I was available.
Exactly.
Of what relevance is that to your investigation?
Excuse me.
Of what relevance is that to your investigation?
It's his affidavit, which he spoke about during the course of the interview.
Say that again, please.
It's his affidavit
Yes.
that
I'm interested to find out what question had you posed to receive that answer from him? Or was he just, did he just volunteer the information?
it was a flow.
Okay.
It came in the flow.
All right.
He's
So
talking- yes.
we realize here his unhappiness over about General Khumalo choosing Major General Gabela over him. He continues.
Before you
Yeah.
continue, can I, because of the similarities, nearly word for word of this paragraph 6 and the next ones that Ms. Silva is going to be discussing with you, did you base your affidavit on General Khan's statement, this affidavit, where you make allegations about TSS being a very critical covert crime intelligence operational post? You've said exactly that. I also cannot understand why Khumalo invited Gabela and so on. I just want to know who of the two of you is the original source of that kind of complaint, because it's exactly the same that you've got. Did you take it from his affidavit into your affidavit, in which case it is his complaint about this, not yours, or did he copy your affidavit?
Thank you, Chair, Commissioners. It's part of mine because I know the environment, I worked with it, I know the technical support unit post, and I'm acquainted with the environment. So it's part mine. So with regards to General Khan and his affidavit, it's a flow from his. It's not that it's like I did not know about it and then now he's telling me I'm getting to know it. I'm already know about it. And he's just talking about it and it's a flow in it. So that's explanation there.
The reason I ask is, for example, in an earlier discussion, we agreed that there's nothing wrong, at least according to policies and prescripts, in having brought in somebody from outside, crime intelligence. That's accused number 5, right? Yes. We've agreed it's not precluded by the policies. And yet in paragraph 6, General Khan says, I also cannot understand why Khumalo invited Major General Gabela to form part of the interviewing panel as I was available. He says that. You say exactly the same thing in your affidavit. So I'm asking, do you say it in your affidavit because that's what Khan complained about, General Khan complained about it, and that's why it's reflected in pretty much the same terms in your affidavit, or did he look at your affidavit and then included it in his affidavit?
No, he had no insight. Sorry, Commissioner, carry on.
Yeah, no, sure, you can.
Thank you, Chair. Thank you, Commissioners. No, he had no insight into my affidavit. Like I said, I've already known about the post.
But you had insight into his, I assume. I mean, you had already taken his statement by the time you were applying for a warrant?
My affidavit was taken, my anchor affidavit was taken during that time. But also, I think it was just when I did the arrest warrant, in the arrest warrant affidavit when it was in there. But he did not have insight into it. I think Major General Khan was the only general at that time at Crime Intelligence beside General Khumalo. I think, if I'm not mistaken, the other general that was available was not there. He was suspended, or I'm not sure. But there were just the 2 generals there. So that's why it comes up as that General Khan at head office and the provincial heads. Thank you, Chair.
Thank you, Mr.
Can we do this, Colonel? Let's just put this idea to bed that the requirements of the job were somehow fashioned to favor a candidate. Those requirements have always been like that. 3 years prior, if you go to the 2022 advert on page 470 of file 2, they're identical. So it's not something new that was fraudulently introduced in 2024. If you go to 470 of file 2, you will see that it was always the case that they wanted somebody with LLB, somebody with public administration, somebody with 3-year degree. Are you there?
Yes, I'm with you.
Yeah. So the idea that they don't know why it should have gone outside, why it was done so in 2024, but even the approved posts in 2022, if you look at the date, April 2022, on page 470, it's exactly that.
Chair, yes, 2022, 2023, when you look, Chair, what I want to point out, when we requested for the documents on the advertisements, these earlier ones, we did not get it. They didn't put it in the
So
bundle.
now that you've seen them,
Now that I've seen them, when you look at 2022, 2023, and 2024, the requirements are the same.
they were still the same over
They're
3
still
years.
the same. Just that the first two were internal and the last one was external.
Maybe something else to put to bed arising from this discussion with Commissioner Kumalo is that Van Vieren that you say has 40 years experience and could not have not qualified for this position was in fact overlooked, was not shortlisted in a previous round which included General Khan. Because remember, General Khan was part of the panel previously.
Yes, I just
So
have
he
to just
didn't make the
check.
shortlist. Van
I just
Vieren.
have to check whether he was part of the panel. I'm not sure. I didn't check on
I
that.
think he was. I can be corrected if I'm wrong, but my recollection of that panel is he was there. But the important point that I'm making about it is the very person that you say has 40 years experience and in fact is most suitable for that, would have been the most suitable for that position, in fact was not even shortlisted in a previous round, which comprised crime intelligence people.
Yes,
Thank you.
acknowledged.
So remember, we're still dealing with General Khan's affidavit where he says, this is a specialized, this is internal, this is this. And I'm pointing out to you that even 2-3 years prior, lawyers were invited to apply. People in public administration were invited to apply.
Yes.
People who were electrical and mechanical engineers were invited to apply. So it's not something new that is introduced in late 2024 to favor a particular individual. Even in prior years when she was not even in the picture, those were the requirements for the job. They did not change to favor her.
Those were the requirements on the 22, 23, and 24.
Exactly.
Yes, Commissioner.
Thank you, Commissioners. And just, Commissioner Balo, you are correct. In the 2023 panel, General Khan was a member. I put it up, it's there. So,
Thank you.
thank you. Let's continue to his paragraph 7. He says, I have viewed the file regarding Makwele's appointment, and what is evident from the file is that Kumalo, Madondo, Lekalakala, and Gabela unduly favored Makwele above experienced colonels within the immediate environment who met all the requirements during the panel sittings. Do you see that?
Yes.
Now, my first question is, he says, I have viewed the file regarding Makwele's appointment. Did you provide him with that? Did you provide General Khan with the file regarding Makwele's appointment?
During the course of the interview, I had the file in front of me.
So that's the one he viewed.
Yes.
So you did provide.
So you provided him with that file?
No, he was not provided the file. It was during the course of the interview.
No, Colonel. No, come on.
Colonel, for him to view the file, you must give it to him. If you are interviewing him and it's with you, he can't view it. So you must have given it to him to view it, for him to form that view in that paragraph.
Yes, sir. During the course of the interview.
Was that we are seeking to obtain a statement from a witness. Is it proper to give him that file for him to prepare a witness statement in circumstances where you intend to proffer criminal charges against senior members of crime intelligence? Do you consider that appropriate to do?
Counsel, Commissioner, Chair, during the course of the interview, whilst I was busy with it, I had the file open and I was going through the file during the course of the interview. Yes, I acknowledge what you are saying, that is it proper
Yes.
for him to view the file?
No. You just conceded to the commissioners that, yes, actually you gave him the file. So you gave him access and permission to view that file. So we are past that now. I'm
Yes.
asking as to the propriety of that decision and conduct on your part. Do you consider that proper? In circumstances where you are seeking him to provide you with a witness statement for potential criminal charges to be brought against senior members within the institution you're investigating. It's either you consider it proper or it's not proper. There's nothing to debate. If you're happy with it, I'll move on.
Chair, Commissioner, at that moment in time, I did not consider that.
You did not?
I did not consider that.
In
during that
okay,
time.
now that we are here, in retrospect, do you think it was proper for you to have done that?
No, I don't think it was. I mean, I'm sitting there and I'm interviewing him and I'm listening to him and taking an affidavit and then referring to the file. So I cannot see the reason why you say that I would have done something wrong by showing him the file.
Because you are influencing the content of his witness statement. So he's no longer deposing to an affidavit on facts he knows something about. You are feeding him the information and thereby influencing what goes into his witness statement. That is the problem. Did you ever give any other witness this file to say, these are the contents of the file, now go give me a witness statement? Have you done that in this investigation?
That is noted, Counsel.
Okay.
But at that moment in time, taking the affidavit and the process of interviewing him, it's a referral to the file. But as you put it, I did not see it like that at that time. Is my witness there, not putting words in his mouth, and saying, listen, look at this, look at this, look at this. I'm busy interviewing him, referring to a file, and going on with it. It's at that matter in time, Chair, Commissioners. Thank you.
My comment to you that it's highly improper. You are affecting the objective quality and the probative value of that witness statement because you have as an investigator, you have influenced the content of that statement. That witness is no longer talking the absolute truth from the basis of what they know. It's what they know embellished by what you have told them. And I say that is improper. Do you have a comment to that?
Noted.
Oh, yeah. Okay, noted. Now, if we move on at paragraph 9. Paragraph 9 and 10, he concludes, if I was consulted prior to the post being advertised externally, I would have advised Khumalo against doing so because the post is very specialized and operates in secret within the operational covert crime intelligence policing environment. At 10, I believe that Khumalo did not nominate me to form part of this interview panel, as I would have opted to appoint a more competent and experienced senior officer from within the crime intelligence environment. We know that he was a member of the panel in 2023. He failed to achieve precisely what he sets out in paragraph 10 from officers within the crime intelligence environment. He failed. He was a part of that panel. And in 2024, miraculously, he would have found one.
Yes.
So what is the value of this statement to the criminal case that you are trying to investigate, if not a gripe session by General Khan that he happened not to be a part of an interview panel that appointed Mrs. Makwele in circumstances where neither the policy, prescripts, constitution, or any religious belief entitle him to be appointed to this panel. What value is that to your investigation?
This is his affidavit that, in the interview, this is his affidavit, and that's what I can say for you.
Yes.
Chair.
Now, you remember we discussed the letter that he commented on, and in fact, you go further in your affidavit in the arrest warrant, you deal with the issue of vetting. 2379, we're at the tail end. Page 2379, it's file what? File 6
We are at the tail end of the file or the tail end of today's session.
of today's session, Commissioner.
I've got it. This is it, yeah. 2379, I got it.
That's still your affidavit that we had looked at. At 8.9, 2379, you say Ngube compiled a letter wherein she represented that Makwele had applied to be vetted. This was not true, as it would have been impossible for Makwele to apply, so she did not have a personal number. You see that? Okay.
Correct.
Now, you recall, if we go to our file 2, that file 2 is where we have the file on this entire recruitment process. In there, you will find under CJC 370.12,
You know which one it is?
CJC 370.12. Three seven three, no, 370.12. Page 373.
370.
370.12, that's the exhibit number. The page is 373, file 2. Are you winning?
Getting there.
No, we need to get there. They'll help you now.
370.
Okay. Now, under CJC 370.12, it's a series of letters. The first at 373 is to Commander G. Janse van Rensburg. If you go to 373,
Van Vuren.
Jesus. Van Vuren, for the record, I apologize, Chair. Commander G. Janse van Vuren. At page 375, it's to G. Makwele, and at 377, it's to Colonel Bapela. All these letters are the same, if you look at them. They are invitation letters. They are worded exactly the same. What only differs is the addressee. And midway, let's take 373, which is Commander Van Vuren's letter, invitation letter. At paragraph 1, of course, it congratulates. It tells him that he is part of a short list. 3, and then it speaks about the evaluation process that will be over 2 days. And then at the bottom, in bold, it says, kindly take note of the following request. At 373, it reflects that the candidate should bring original certificates and copies of all qualifications, driver's license, and some such documents. Overleaf, at bullet point 2, it says, if you are not in possession of a valid security clearance to the level of top secret, proof of application for such clearance must be submitted on the first day. Please note that all applications for security clearances are done via e-vetting. Do you see that?
Correct.
Now, if you go to 375, that's the start of Mrs. Makwele's letter, similar letter. And the same at 376, she is informed that if she's not in possession of a valid security clearance to the level of top secret, proof of application for such clearance must be submitted. So, my interpretation of this document, and it might be wholly wrong, I accept, is that all the shortlisted people, when they presented themselves for the interview, were required to at least produce a top clearance certificate or an application for one. Now, Ms. Makwele doesn't have a personal number, which is the point you make at your paragraph 8.9 of the affidavit. How was she to provide proof that she has applied for clearance certificate? Because the invitation letter actually instructs her to bring proof of such application. She doesn't have a personal number. How was she to do that?
First of all, the application, when you apply for the post, it's in the application regarding the security clearance. You can, it says there that you must get a security clearance within 6 months of your appointment. Now, she's a civilian. She cannot apply via the e-vetting system. So this should have been brought to the attention of the panel, or when she went to the assessment center or spoken to somebody. I'm a civilian. I cannot apply.
Colonel, they issued an advert for civilians to apply. They
Yes.
don't have personal numbers.
Yes.
But the process requires that by the time they present themselves for an interview, they must at least show that they have applied for vetting.
Yes.
So-
Now, she couldn't apply. So that's valid. You couldn't apply because she doesn't have a force number, right? So what Brigadier Ngube did is that she went and did it via how you appoint a service provider. And
Okay.
then wrote a letter to say it is done on the e-vetting system. Whereas you write a letter to say that Ms. Makwele doesn't have a force number, but her application form for vetting has been completed and acknowledged that she's received it. But to apply for it and register it on the e-vetting system, you can't because you don't have a commander. The commander must sign off on it, and it cannot be captured. So the inquiry that deals with service providers, she went and did it there, where it's totally unnecessary. As a civilian, you don't have a force number, so you put in your application, you have a copy of your application form completed, but the details of your commander would not be there. I'm just saying now
Yes.
what should have been done,
Yes.
not to manipulate the system.
Okay.
So this is what should have been done with Brigadier Makwele, who's the head of the vetting system, should know better. Write a letter.
Brigadier Ngube, I think.
Yes, write a letter to say that the applicant is a civilian and does not have a force number, and therefore she cannot apply via the e-vetting system.
Okay.
But Brigadier Ngube went and took the same thing and done it on the inquiry. Then she writes a letter, and in the letter she lies.
Okay. Let me just test this logic. And this is just logic. I apply logic to this process. People are coming in for an interview for consideration to be appointed to that very sensitive environment, as you have so extensively described in your affidavit. That letter seemed to suggest that before you come into the interview, you must have entered your details into some system, because that system begins to check me, because they could very well be wasting their time interviewing somebody who's got 4 active warrants of arrest out there. That would make sense if that's the purpose, right? To start checking me as I come for the interview. So they don't want to interview somebody who has not begun a process of vetting. Now, how does a civilian achieve that? You say you complete a form, a written form that's going to be filed, but there's nothing that is acting on my details to see whether or not I should even be considered for an interview.
You got your invitation letter,
Yes.
your ID, you go to the assessment That's all you need.
No, that's fine, but it's this invitation letter that requires
Yes.
a start of a vetting process. And we agree that because she's not a government employee, she doesn't have a personal number. She can't be vetted like Commander Van Vuren and I forget his, Bapela. I apologize, I forget the rank. But she's a civilian, but the process must start. So for me, logic would dictate that, say, we have to enter your name into the system to start finding out about you. Because perhaps, I don't know how the systems work, but they might just throw a red flag and communicate directly to the panel that they shouldn't even let me through that door. If anything, they should call subs because I'm a wanted person. That might be the value.
At the time,
Do you have a difficulty with that?
Council?
Do you have a difficulty with that logic that I'm applying to why?
I do.
Okay,
Because
tell me your
it's
difficulty.
basically straightforward. She's got an invitation letter the way it's at the bottom. Kindly take note of the following: original certificate and copies of qualifications, driver's license, and ID. You must come with it.
To go where?
The fact remains here is that you cannot. It's a vetting system. It's security clearance. You cannot get into the e-vetting and log it because you don't have a personal number and you don't have a commander. This is identified by the people that sent the letter to her and invited her would have known. But beside the fact, just write a letter addressed to the panel that Ms. Makwele has completed an application. There's no command on it. It cannot be captured on the e-vetting system because she does not have a personnel number. She's not yet appointed. Finished.
Okay.
But now you cannot go to the inquiry system and register there as a service provider just to get that there.
All right.
That proof.
Isn't that then an internal irregularity? Because if the chairperson of the panel says, go through the e-vetting system, these letters are from the chairperson of the panel, addressed to all the candidates to say, that's how you should go about it, and that's the person you should contact. So it's not the case of candidates themselves doing something that is improper.
Commissioners, we're not talking about Mrs. Makwele doing something irregular. We're talking about Brigadier Makwele, who is the head of the vetting system that should have known better. But she writes,
With this. You have one of your charges, the charge against Ngube is on this issue, is
Yes.
Ngube and Makwele. So
Yes.
according to you, Makwele has done something wrong
Yes.
by being put on the, what do you call it? Inkwazi.
On the service provider.
Yeah, you say
Yes, on
she's
the-
done something wrong.
yes.
And yet I understand you now to be saying, yeah, it's a Ngube problem. Why would you charge her with this?
All that we have, the commissioners, we don't know what was the communication between Makwele and Ngube. But what we know, we have a letter from Ngube that where she's saying that Mrs. Makwele has been registered on the e-vetting system. And Mrs. Makwele herself knows that's not the fact. She's registered on another inquiry system. But be that as it may, both of them are charged according to the charge sheet. Is that what you say, Commissioner Beloy? I think that charge sheet that you have that must be the initial draft charge sheet that is there. Bear in mind that as you go into the court processes and just before pre-trial, those charge sheets are finalized as to way forward. So,
Even so, even allowing for that, you remember why we are having this long discussion with you since yesterday. Keep that in mind. So even allowing for that, this is not necessarily the final charge sheet, that you would, from the onset charge her, in your first draft charge sheet, that you include her under this charge, that she was placed on the service provider Inkwazi platform.
Yes.
When the letter you're referring to from Brigadier Ncube doesn't say anything about her, her collusion, and your charge is she colluded.
Yes.
And if that letter is the only basis on which you have included her in that charge about her vetting being on the Inkwazi, one, on the face of it, it seems truly, truly petty to charge her with that when you have absolutely no basis, but also considering that you understand she could not have been on the e-vetting system, because you say you understand it, you know that she couldn't have been there. In fact, when I say it's petty, at best it's pettiness, but it suggests something much more sinister, because you do not have facts that implicate her in being on the Inkwazi platform, and yet vetting platform.
Yes.
Yeah, you don't implicate her in the Ncube letter, because that letter says nothing about her. And if you want to say, oh, it is that letter that makes me include her with this charge, then I'm going to say, well, you seem to be prepared to suck up facts out of thin air which are not supported by anything. If you say this letter implicates her, the letter doesn't on its terms. It makes absolutely no reference to her.
Yes.
You know she could not have been on the e-vetting platform, according to you, because she doesn't have a commander, she doesn't have a PESAL number. She gets put onto the service provider platform by somebody else. You include that against her. You make her complicit. You say, that's your wedding. You say she was in a conspiracy, she colluded with Ncube in a document that is seeking to get you an arrest warrant against her. So it's not just an affidavit that's lying around in your office. You make those allegations in a charge sheet that you're going to present when she applies for bail. The court sees, the magistrate sees a charge sheet at that point that says she colluded with Brigadier Ncube to be placed on this platform, when you have absolutely zero facts that justify that. That's a problem. It's a serious problem, Kelden. It is. You had no facts whatsoever. You made it up. You made it up to include her in this charge. And that's deeply problematic. In fact, it speaks to, until it's explained properly and satisfactorily why you included her on this charge, it speaks to an abuse of your power and authority to victimize an innocent person, at least on this charge, when you have no facts about it. You can comment if you want to.
Thank you, Commissioner. I note you say I included her on the charge sheet. I'm at pains at that. It's my affidavit, my investigation, my affidavit is given. I don't draft the charge sheets and say who must be charged for, who must be charged, what charge is there. I don't. That is at the prosecutor's door. They make that determination. So
I'm prepared to accept that, and what you're doing with that answer, in fact, what that answer does,
yes,
is it causes us to call the prosecutor to come and explain how these charges were formulated. I do accept your answer, and I won't persist in this.
Thank you.
If we then move on this vetting issue, and I invite you to CJC 37013, 13, same file, page 381. Once again, it's a pack of letters, it's the same. I think it starts at 380. It's the same letter addressed to the three candidates. And it's said it's a letter of confirmation. We can look at the one at 380. And it is signed by Brigadier Ncube. That is that letter we considered that you put before General Khan because it has got his name at the top there under inquiries. You remember this letter? Do you remember this letter that we are looking at 380? That's the letter that General Khan speaks to, which Brigadier Ncube signed.
380 is Van Vuren.
Chair, Advocate Silo, to be fair to Colonel, the one we were looking at was the Makwele letter,
Okay.
381.
Let's go
Although
to
they are the
381.
same.
They are the same. Let's go to 381. They're all, okay, the point, let's start at 380. We're looking at 381, right? And that's the Makwele letter. That is, it's worded in the exact same terms as the one at 380 for Van Vuren.
Yes.
You confirm? And similarly, for the one at 382 for Bapela.
That's correct.
So it's the same letter.
Yes.
Okay, if it's more comfortable to look at the Makwele one, let's go to the Makwele one at 381. It is signed by Brigadier Ncube. It's the one that has got the name of General Khan at the top under inquiries. The one that General Khan speaks to in his affidavit. You remember we discussed it?
Yes.
You nod. And at paragraph 1 says, this confirmation letter is to officially state that on 25th July 24, the applicant, Mrs. Makwele, it's got an ID number there, will skip, submitted an online application on the South African Police Services SAPS-E vetting system for top clearance security with a particular reference. It then says the top secret security clearance application of Mrs. Makwele was received by the vetting authority for review and approval in potentially granting the required security clearance for her specific position in SAPS. It concludes, however, the top secret security clearance application of Mrs. Makwele's, I think, eligibility is pending and not yet finalized. Do you see that?
I see that.
This is dated 25th of July 2024.
Correct.
You remember we had those invitation letters that say go via the vetting department there and submit your details, and then they come back with this letter of confirmation that they have subjected themselves to that process as prescribed by the letter of invitation.
Yes, the letter of invitation.
None of these two letters constitute giving Mrs. Makwele a clearance certificate. Do you confirm? Because this very letter we are talking about, we are looking at, he says that clearance, that top secret security clearance or application of Mrs. Makwele, it says is eligibility pending and is not yet finalized. There's some wording issue there. But the key issue is that it's not finalized. It just acknowledges that they have received something from her. Do you agree?
Yes, I agree.
Okay.
That I can agree to what she's saying here and the fact that they've received it. But what the content of it, that she confirms that she submitted an online application.
No, I hear that. All I'm saying is neither of the two letters we have looked at constitute approval or grant of a top clearance, top secret clearance. They are not doing that.
No,
They're just recognizing and acknowledging that a process was initiated.
No, it does not refer to them giving us a top secret clearance.
Yes.
It just talks to an application. To give a clearance would be impossible to give it almost immediately.
Now, that's what we have in that recruitment file, insofar as vetting is concerned. If we go back to your affidavit, 2378, I hope you haven't lost it. That is the warrant of arrest affidavit. No, 2379, my apologies. 2379. About the panel referring, amongst others, Mrs. Makwele to go to the e-vetting system and be registered there before she comes for the interview. And now we know after that process, she receives the letter we've just looked at that confirms that yes, she did subject herself to that process. At 8.11, you conclude, Ncube should not have done this as Makwele was only supposed to apply for vetting after she received a letter of conditional appointment. You are now after the appointment, but where we are is even pre-interview. So are you suggesting that she ought not to have been subjected to any vetting process until she was awarded a letter of conditional appointment? Is that how I should understand it?
Your whole vetting process will kick off once you receive a conditional letter of appointment.
Oh, okay.
That's how you understand it.
I'm with you.
So according to the advert, according to the application, it's all there. And even though you have this letter of invitation to come, and this is what must be done as proof.
So your problem is that she was subjected to a vetting process, some form of vetting process, or an attempt to do so prior to her receiving a letter of conditional appointment. I'm trying to understand what's the sting in the complaint?
The vetting process hadn't started. What she did to get through and comply with the letter, she could not register on the e-vetting system because she has no force number and no commander. Right?
But then, Colonel, all that means is that the letter of 24 July was disadvantaging her, or the letter before this one, because that letter said, before you come to the interviews, bring your IDs and other things, and then submit your vetting application through the e-vetting system. That was not required. It could have been done within 6 months after her appointment.
It's correct.
So the fact that that letter was sent to her means it was disadvantaging her because it was requiring her to go through something which was actually not required.
Chair, Commissioners, exactly so.
So
She
then
was-
why would you charge her for that? That she's being disadvantaged. She's not being benefited by that thing. She's being disadvantaged. Why would that then constitute a charge or an offense by her? If she's being required to do something that she's not even supposed to do, because vetting is required within 6 months of appointment, not before you come for an interview.
Exactly, Chair. As I said initially to Commissioner Beloy in my response to her, I do not draft the charges.
And then we've been there before that
Yes.
the prosecutor gets all that information from your affidavit, takes your affidavit and says, here is the affidavit, this is what it says, these are the facts it puts up, this is what it says is wrong with this whole process. Then they put it in a charge. So what Advocate Sillo was showing you in 2379, that's not the charge sheet, that's your affidavit. Because the charge sheet follows at 2418. 2379 that she was referring you to, that's your affidavit, which formed the basis of a later charge.
Noted, Chair. My affidavit 8.9, 8.10, 8.11, and 8.12. I'm trying to understand where Commissioner draws that I mentioned Makwele.
In 8.9, Ncube compiled the letter. She misrepresented that Makwele had applied on the e-vetting system. This was not true, as it would have been impossible for Makwele to apply, so as she did not have a PESAL number. Through Ncube's unlawful and intentional action, Makwele's application was registered to trigger the vetting process. And that formed the basis of the charge sheet, which was later formulated. Because absent this information, there is no way a prosecutor should have said, oh, there's a charge there too, there's a charge there too.
Therefore, Chair, Commissioners, what I'm saying to you, my affidavit does not say that Makwele must be charged for corruption because she colluded with Ngube. This affidavit is done. The prosecutors prepared the charges for Makwele. But my affidavit here, as you can see clear, Chair, it does not show that Makwele colluded with Ngube. It talks to Ngube only.
But you see, it also doesn't say Makwele had nothing to do with what I've set out in 8.9, 8.10, and 8.11.
Sorry, Chair, I can't hear you.
I'm saying your affidavit also does not say Makwele had nothing to do with what is set out in 8.9, 8.10, and 8.11.
Chair, Commissioner, the fact that it's not there, I would put it there if she had something to do with it. The fact that it's not there, does it make it wrong? I don't know. I don't know.
But you see, Colonel, your problem is this. You must know that the prosecutor is going to rely on your affidavit to draft the charge sheet. And anything that is not clear, you have to clarify it. Because if you leave it open-ended, reading 8.9, 8.10, and 8.11 together suggests that Ngube and Makwele did something wrong. And nowhere do you say, I don't blame Makwele for this is on Ngube, so it must be left to Brigadier Ngube.
Can I respond to you?
Yes.
Chair, Commissioners, this is my affidavit. In my affidavit, I believe that I have put in here Ngube and I haven't put in Makwele here, and this is my affidavit. And as Commissioner says, no, you should have put Makwele in here to say there's nothing. I can take that no further, except to say there's my affidavit, I've put it in there, I've referenced to Ngube what she's done. I didn't indicate that Makwele sort of, she and Ngube got together and they did something wrong. And this is my affidavit, and I can take it no further.
Just one last point on this. So when the prosecutor drafts the charge sheet, I'm assuming they will start with a draft. Do they not discuss it with you before they finalize it? Just to make sure that the facts they have put in the charge sheet are consistent with your investigation and your affidavit. Don't they say to you, I've looked at everything, I've looked at the docket, I've looked at your affidavit, I've now drafted a charge sheet. Have a look at it and confirm that I've recorded the facts correctly. Don't they do that?
That does not happen on this occasion, Chair.
But
If I say that it had happened, then I'll be lying. It did not.
Does
I
it
completed
happen
my
on other occasions?
Sorry, sir?
Does it happen on other occasions?
No, Chair, not that I could recall.
So the IO does not have sight of the charge sheet before it's finalized?
The charge sheet, the affidavit is compiled, it's given to the prosecutors. They compile the charge sheets, and most often the charge sheet is in draft format. And in this case, it was attached to the affidavit. In other cases, I can't really recall that, that maybe there was discussions on other matters, but our affidavit is done, it's given, the prosecutors draft it out, and that's there, as far as I'm concerned there.
So you say, in this case, you annexed the draft charge sheet to your affidavit.
Yes, sir.
Now, did you not see that there were inaccuracies in the charge sheet to the extent that the charge sheet suggests that Ms. Makwele had anything to do with what is set out in 8.9, 8.10, and 8.11 of your affidavit? Did you not ask the same question that Commissioner Baloyi asked? Why is she included in the charge if she had nothing to do with that? Did you not ask the same question?
Yes, Chair, Commissioners, I did not take notice of it on the charge sheet, and that's my saying. I did not take notice of it on the charge sheet. It was a draft charge sheet. I attached my affidavit to it, and I went forward from there. To say anything else means I'm building up another story.
The concern, Colonel, is that you're presenting that charge sheet to the court because you want the court to authorize you to take certain steps, including arrests, including, many other things. One would expect that if you're relying on that draft charge sheet in your affidavit, you should make an effort to study it and satisfy yourself that it accurately reflects what Idac's case is against the people you seek to arrest and to charge.
Thank you, Chair. Commissioner. Noted. Your comment noted, Chair.
I think my concern is deeper than that. I do not, with respect, accept your explanation, Colonel. You caused for somebody to be arrested. Somebody who, on your own facts, was not complicit in the crime that you describe in the charge sheet. But because of your affidavit and the way the charge sheet is drafted, you caused for her arrest. That's irresponsible in the extreme. That's abuse of power. And it is not enough for you to say noted. No, Colonel, I don't accept that. I worry for the rest of the citizenry. Must I? I don't accept your answer. I don't. No, Colonel.
Chair, Commissioners, Council, I note your comment. When I applied for the warrant, there are 2 charges on the warrant which I took notice of. As I said, with regards to the charge sheet, the prosecutors are the legal experts in compiling the charge sheet. And I note that you are saying that what you are saying in your comment against me. I also have a concern. But as I'm saying, and I note what you say, is that the prosecutors are the legal-minded people that put the charges together. I have my affidavit. I've explained it to Chair and Commissioners. And moving from here, I can take that no further. Your comment is noted.
Okay. Thank you. But it's been a tad unfair.
Colonel, you've explained the approval processes, that a charge sheet is drafted and then it will be submitted to management. Eventually, somebody higher up gets to approve. Now, that higher up people beyond you, so it's you, but it moves on through the stages. They relied on your affidavit. They can say that they relied on your affidavit to approve this charge sheet. And it's simply not good enough that you have it attached to your affidavit, and the charge sheet is attached to your affidavit, and then you say, well, I didn't see it. It's simply not good enough, because you represent, when you sign this affidavit, as you would know, I'm not lecturing you or speaking to you about something that you don't know. As you would know, that when you sign and stand before a commissioner of oaths, you represent that and these are facts that are within your personal knowledge. You take ownership. So that it is drafted by a prosecutor doesn't excuse you whatsoever. It's your affidavit. You represent, I have read the pages. That's why you are asked, when you take the oath, do you know and stand by what is in this affidavit? So from where I'm sitting, I hold that you must be held to have known the contents of your affidavit and of the charge sheet, and you were happy to depose under oath that is your affidavit and you stand by it, including the charge sheet. And you cannot be excused on the basis that it's drafted by a prosecutor, but also I didn't notice. It simply doesn't. It's an excuse that is not available to you. You are responsible for this affidavit. You represent it to a court that this is your affidavit, it contains your truth, and you must be held to that. You can comment if you want to.
Not the Chair. You've mentioned it.
Thank you.
Staying with that paragraph 8.11, we are still at your page 2379 of your affidavit. We've just dealt with the point you make that Mrs. Makwele was only supposed to apply for vetting after she had received a letter of conditional appointment. I'm interested in the concluding sentence in that paragraph. Civilian vetting where required must be done through the state security agency. You see that? Your affidavit, the application for warrant of arrest, I'm at 2379. We dealt with the first part of paragraph 8.11. I'm now at the tail end of that paragraph 8.11. Do you see where I'm reading from?
At the bottom of 8.11,
Yes.
civilian vetting
Yes.
where required must be done through state security agents.
That's correct.
That's more or less where civilian people will have the vetting done.
I see what my question
Yes.
is coming. What is the source of that claim? On what basis do you say that she ought to have gone through the state security agencies? Is there an act, a policy, some form of prescript that so prescribes? That for a civilian, the vetting must happen through the SSA.
What's in there is that, what I stated there is that civilian vettings are normally done through state security agents.
Now you say must be done through SSA. That there has to be a source of that somewhere. What is the source? Is it an act? Is it regulation? Is it anything that you can point us towards?
Act regulation with regards to security vetting at state.
Yeah, what prescribes that civilians in these circumstances must be vetted by SSA?
There's no particular act or regulation that I refer to. It's just a statement that I made.
So you can't then be correct that civilian vetting where required must be done through SSA. That's not a fact.
No.
There's
just
a
part of-
suggestion of perhaps how
Yes.
it
It's a
could have been.
suggestion.
Okay,
It's not a suggestion. I can't take that further.
All right.
Thank you, Council.
thanks. Then lastly, I guess, to close on this topic,
Can we do
yes.
this just for completeness? On the following page, 2380, at paragraph 11.
yes,
It's an issue we discussed a few minutes ago. You say to the court, the attached draft charge sheet outlines the acts committed by each of the 7 suspects in a very comprehensive way, which includes charges of corruption, defeating or obstructing the administration of justice, and perjury. See Annexure A. So you are telling the court that what is in the charge sheet is an outline of the acts committed by each of the 7 accused. It's you who's saying that to the court.
Noted there, Chair. I acknowledge that.
Are you? And the perjury here would have been what?
The perjury would have been where you signed under oath that the information that you provided is true and correct.
Yes. And what was the information that was incorrect?
I think it was on the application form. If I just got to look back on my memory into it.
You don't remember offhand?
Not offhand.
Okay, and then defeating or obstructing the administration of justice would have been what here? Remember, we are talking about a recruitment process, a panel, vetting, scoring. What would have been obstructing the course of justice here?
I'll have to look at this again and go through my stuff, Commissioner, to respond on that in terms of the charges that are there. To just pop it out now, also it's been a long day, but nonetheless, what I'm saying is that I have to go back and look at this part of thing you brought to my attention now.
Okay, but for now, you don't have an answer to my question. So I must deal with it on the basis my question is not answered.
Question not answered, Chair.
Thank you.
Staying on the page, if we go to the top, your affidavit states at the top of 2380 at paragraph 8.12, Ncube therefore ensured that Makwele received an undue advantage in circumstances where it prejudiced the subs, CI, and TSS. What undue advantage is this, and what was the prejudice to those institutions? Because this is a conclusion.
Yes.
I don't understand what undue advantage did Mrs. Makwele receive by being subjected to a vetting process before the interview and then bringing back the letter signed by Brigadier Ncube to say that she has submitted. But no, it's still underway, the vetting process. What undue benefit did she derive, and what prejudice did subs, CI, and TSS suffer?
The fact that of the manipulating of the vetting process or the application and the letter that is there, that it prejudiced, I put there that it prejudiced the subs, CI and TSB, subs, TSS, it's all one component. That's what I meant there.
Okay, and the undue advantage she received, what is that advantage?
The undue advantage is that a clearance has been done, meaning the application process that she's registered on the system. When
But
was
she
not.
hasn't been cleared, we do know
No,
that.
It's not the security clearance that is approved.
Yes.
That to say that process of being registered on the system.
Of being subjected to a vetting process, it has begun. That is what we
the
agree the two letters mean.
That the
She's not
applica-
cleared yet.
That the application form has been done on the e-vetting system
Yes.
when it was not.
So what's the advantage to her?
Well, the requirements what was meant for her with regards to getting registered on the e-vetting system and putting the application in, it was not done. So that just gave her the advantage of her now going for the interview. That process is met when it is not met.
Okay. Lastly, then, let's just look, having worked through this vetting issue, let's go to the charge sheet as drafted by whoever. At 2425, we're staying with the same file of your affidavit. The charge sheet on this issue concludes at 12.13, that's where I'm at, page 2425. At 12.13, it states misrepresentations were also made by the accused with regards to the vetting application by accused number 7, that's Mrs. Makwele, resulting in her getting a security clearance she was not qualified to get. Where does anyone get the idea that as at the time this charge sheet was drafted, Mrs. Makwele had a security clearance?
When I look at this paragraph now in hindsight,
Yes.
it is the vetting application.
Okay. What about the vetting application?
That is to get it registered on the system.
Okay, so the
Yes.
part that resulting in her getting a security clearance, that's
Yes,
factually
not a
incorrect
security
because she
clearance.
did not get a vetting
No,
clear. Okay. And in fact, we know that she was, having been recommended, she had 6 months to get through the vetting process.
Yes.
So her appointment was conditional, amongst others,
Yes.
on her being cleared, but for that she had 6 months.
That's correct. Yeah.
Okay. I will,
And then she was charged before that 6 months even expired.
Chair.
She was arrested before that 6 months even expired.
That's correct, Chair.
I would like to move to a very short topic, which is my last topic.
Sorry, can I?
Absolutely.
I just want to clarify something before you leave the charge sheet. I'm looking at, in that charge sheet, I'm looking in the bundle, page 2426, under the heading Legal Framework. If you would just go there.
2426, Commissioner.
2426, yeah. And then you've got capital A, Legal Framework. You see that? Legal Framework, the heading. At
Legal framework.
2426?
Yes, sir.
Are you there?
5-7.
Are you there? Are you on that page? Okay. So under that heading of legal framework, you set out provisions of PRECA, right? Up to page 2432. That is the framework, the legal framework you set out.
Yes.
And then that's the only legal framework that you discuss in this document. So we can take it that you place reliance solely on PRECA for these charges, because that's the only legal framework you're discussing. I just want to make sure if that is correct. That's what I'm reading correctly.
No, it's not the only one.
Okay. What else? And where do I see that? In the charge sheet.
In my affidavit, yes, I put in this legal framework of PRECA, but PRECA was not the only thing that was there.
Okay. What else? I'm looking at the charge sheet, remember? I'm not looking at the affidavit at this stage. I'm looking at the charge sheet, and I want to propose something, but I need first to know that I'm correct in the way I'm reading your charge sheet. It has one heading, which is legal framework.
Yes,
and
the
then
charge sheet.
it discusses PRECA, which sort of suggests that that's the and then you've got a heading at 2433, which is corruption charges.
Yes.
So, and then I ask, this must mean that you based these charges on PRECA.
According to the charge sheet.
Yes,
That's written.
according to
This
the
is
charge sheet. According to the charge sheet.
Yes.
Okay, all right. And the charges accordingly, in fact, the way that the charges are formulated, the counts, count one up to the last one, you make reference to PRECA
On the
on
charge.
all the counts. All your counts are PRECA-based counts, except for one. There's the fraud, which you base on the Criminal Procedure Act. You're right. So you don't rely only on PRECA.
No, don't only rely on PRECA because.
Okay.
Yes.
You rely also on the CPA, the Criminal Procedure Act.
Sorry.
You rely also on the Criminal Procedure Act.
Criminal Procedure Act, yes. This charge sheet, Commissioner, as I said, this is drafted by the prosecutor.
Yeah, but it's your charge sheet.
Acknowledged, Judge.
Okay, all right. Now, I was just confirming that is it
Yes.
solely PRECA or you rely on other provisions as well of the law?
Yes, you're relying on
Okay.
other precepts of the law, the Criminal Procedure Act, etc.
I have to correct myself. Thank you, Chair. It's Criminal Law Amendment Act, not, you didn't correct me. You should have corrected me, not Criminal Procedure Act, Criminal Law Amendment Act.
I'm sorry, Commissioner, it's that time.
For me too. All right, thank you.
Thank you, Commissioner.
Colonel, and I promise this is the last very small point. We are now at a point where they've been arrested, they've applied for bail, they are granted bail. You recall they then approached the court to amend the bail conditions. Okay. That's where we are at. For this, I would like us to go to file 7, page 2950.
Okay, Silo,
Will be in a different
I want to ask very quickly, 2438.
And absolutely, Commissioner.
We discussed this earlier in file 6. I want to make sense of the file where the charge sheet is, the file where the charge sheet is file 6. I'm looking at page 2438. 2438.
Sorry, give me 24339.
2438. Now, in our earlier engagement, you gave us the process and you created the impression that it's the prosecutors who decide to charge and Idac, sits in the back. But reading this letter is from the Acting Director of Public Prosecutions, Gauteng Division, Pretoria, and it's addressed to Advocate Johnson, Director at Idac. And it says, your correspondence dated 24 June 2025 in connection with the above matter refers, I have read the consultation note as well as the draft charge sheet attached to the above correspondence. Now that suggests to me that Idac put together the draft charge sheet and not the other way around. And then look at the last paragraph. Having considered the contents of all this documentation, that would include the draft charge sheet, I'm satisfied that a prima facie case has been made out against the accused and the suspects, and I concur with your decision to charge. So Idac's decision to charge them on the offenses as set out in the charge. So isn't that how it happened and not the other way around?
Commissioner, this is a consultation note that is between the head of office, the ID, and the Director of Public Prosecutions. I have no role in this.
But do you doubt the accuracy of this document? It doesn't reflect what happened.
I'm not saying I doubt the accuracy of the document. What I'm basically saying is that this is a communique between the head of Idac management and the Director of Public Prosecutions. If there's something specifically that you want me to say on it.
And I'm saying it sets out what happened from the 24th, and it says there's a consultation note as well as a draft charge sheet attached to the above correspondence. That's the correspondence of 24 June 2025. And then it says, having considered all the documents, I concur with your decision to charge on the offenses. So the decision was by Idac to charge, and also the draft charge sheet was prepared by Idac.
Yes.
And the Acting Director of Public Prosecutions looked at all of those and said, I agree with Idac.
Chair, Commissioners, no, thank you. I understand what you're saying. Yes, it is Idac that's presenting this to the Director of Public Prosecutions, not the other way around.
Including the draft charge sheet.
Yes, including the judge. It's not done by the Director of Public Prosecution. It's, from the way I understand this and the way I've learned it in the office, is that we want to prosecute this in your province, and there's the consultation note together with that. That's how I understand.
So your earlier evidence to distance yourself from the draft charge sheet, that cannot hold, because the draft charge sheet comes from the investigators, which is Idac.
Chair?
Remember earlier you sought to distance yourself from the draft charge sheet by saying, I'm only responsible for my affidavit. I'm not responsible for the draft charge sheet. That is done by the Director of Public Prosecutions. Now this letter says the opposite. This letter says the Director of Public Prosecutions received the consultation note with the correspondence dated 24 June 2025. Attached to that was a draft charge sheet. And what the director does is they concur with your decision, being Idac's decision, to charge the suspects.
Is it? Correct?
Yes.
That's in the document, yes?
Yes.
Thank you.
But can you really hide behind the fact that the signature on that communication to the DPP is Advocate Johnson's signature? In response to an earlier question, maybe 2 questions or so before, by Commissioner Khumalo, you said, but no, that's a communication between the director, the investigating director, and the DPP, which seems to suggest that you had nothing to do with the charge sheet. Did I understand you? Did I not understand you correctly?
With regards, I'm not.
You said you even used the word communique. I'm choosing to use the word communication. Do you remember saying something like? But that was a communication between, or rather, sent by Advocate Johnson to the DPP.
Let me put it in context there.
Please,
Chair.
yes.
A consultation note
Yes.
is drafted by the head of office, which is Advocate Johnson,
Yes.
to the Director of Public Prosecution. This is it writing to her, and as it indicates, the documents which is given to her, and then she looks at it, and it's the Director of Public Prosecutions. That's her signature at the bottom of it. So Idac wrote to her, so that's correct.
Yes, what I'm saying then is, in the context of Commissioner Khumalo's question, you seem to be continuing to distance yourself in the sense that you are basically saying, even though there's a draft charge sheet from Idac, a draft which was sent to the DPP by Advocate Johnson, you are distancing yourself and saying that was not sent by me. It was sent by Advocate Johnson. So again, distancing yourself, but in a slightly different context now. My question is, but can you do that? You have lived closer to all of this than Advocate Johnson has. And I find it difficult to believe or accept that you would not have had a hand in the drafting of that draft charge sheet.
Commissioner, I think we're missing each other somewhere.
Yes, please,
Yes.
let's meet each other.
Commissioner, the as I said, the draft sheet goes up to the Deputy Director of Public Prosecutions. It's presented before management, and once management is done,
Which management? It goes to the DPP.
the Idac, the head of office with their management.
Okay.
Yes, they have it there, and then it goes to the Director of Public Prosecution. So when you say I'm distancing myself, now I'm trying to understand how you mean that I'm distancing myself when it is there with the head of office and their management, and now it's gone to the Director of Public Prosecutions.
In the sense that everything starts with you, basically.
From the investigation side, sir.
Yes.
That I acknowledge.
And then you...
Yes, I'm part of the process.
Yes,
If I could answer that in a better way. I'm part of the process. I'm one leg in the process from the investigation side.
Mm-hmm.
So when you look
the most important leg,
yes, sir.
you may be part of it, but the most important leg of the process.
Yes, the investigated leg, sir.
All right, thank you.
Thank you, Chair. I'd said we are going to our last very small topic, and for that purpose, I would invite us to go to file 7, page 2950. You recall I made the comment to you that we are now at post-arrest, post-bail application, and we know that some of the accused, the three, Kumalo, Madondo, Lekalakala, appealed one bail condition, you recall that? And what we have at 2950 is the judgment of the High Court in that appeal. You recall this judgment? I think the state opposed it.
Yes, so
Yes.
I can recall.
So if we turn to 2951, Generals Kumalo, Madondo, and Lekalakala are now have been granted bail with certain conditions. At 2951, it specifies at paragraph 1 sub B that they appeal only one condition, and that is the bail condition that they were prohibited from being at any premises of crime intelligence within the Republic while their criminal trial is pending. You remember that condition?
Yes.
Yes. Now, there's a whole lot of detail. The judge then considers what was argued on their behalf and on behalf of the state. If we go to page 2959, at paragraph 19.3, under the heading Analysis of the Appeal, the court notes the legal issue to determine in these proceedings, namely whether the magistrate erred in imposing the bail condition, must be assessed based on the material that was before him and the way he dealt with that information or evidence. So as I understood the argument, it was that that particular condition they were appealing was a condition not requested by the state. Do you agree with me?
Not requested by this?
By the state at the time that they were applying for bail. The state never requested that they be denied access to all crime intelligence officers.
Yes, presentation by the prosecutor. Yes.
The prosecutor never made such a request. And it concludes at page 2960, paragraph 19.7. Having considered then these facts, and then the judge notes that at 19.7, judges and magistrates are expected to give reasons to ensure accountability, transparency, fair appeals, guidance in future cases, and the public's access to justice, even though the Constitution does not explicitly require it. Where a condition is imposed without any party requesting it, the reasons should be recorded so parties understand the decision. Stating reason deters unnecessary appeals and helps the appellate court assess the correctness of the decision. Now, if we go forward again, page 2961. And at 2961, at 19.4, the judge quotes the law and points out that courts are discouraged.
14.
19.14.
You said 4-1.
19.14, thank you, Chair. For the record, at 2961, paragraph 19.14, the court quotes that Supreme Court of Appeal case and highlights that courts are generally discouraged from mero motu dealing with disputes not raised by the parties. At the conclusion of that paragraph, it notes a key aspect of this system is that the parties define the issues for determination, present their arguments, and leave the court to act as a neutral arbiter of matters raised. And then I'll invite us to go to 2962, where at 19.17, the court concludes, or the judge concludes, I'm unable to find any judicial basis on the evidence and submissions before the court for the bail condition that was imposed. In exercising his judicial discretion, the magistrate did not confine his assessment to the facts presented before the court. And in upholding the appeal, the judge concludes at paragraph 20.1 The court's decision to impose the bail condition appealed against was made without identifying any supporting facts. It is arbitrary and incorrect and does not reflect a proper exercise of judicial discretion. In summary, the High Court concluded that that bail condition, which is the only condition that the three were appealing against, that they should not enter any office of crime intelligence until the trial is disposed of, was not requested by the prosecutor. It had no basis, and the magistrate did not have a power to impose such a condition. You understand that?
That's understood
Okay.
from that.
Now, we have from the record, the notes made by the judge of the conditions, and for that same file, please go to page 2949.
The judge, made by the judge or the magistrate?
The magistrate. Apologies, I'm confusing my judicial officers' titles. I'm at 2949. It starts at 2948. If you look at the case above there, that is the case that is reflected at 2954 in the judgment. The judgment has got the High Court case and the Match Court case, the A16/463/2025. So these are the notes coming out of the magistrate's court. Now invite us to 2949, and there is that bail condition that is being appealed against because the magistrate, item 3 under condition states, accused number 1, 3, 4, 5, 6, and 7 are prohibited from being at any premises of crime intelligence within the country RSA while the matter is pending. So that is the condition. Would you know where the magistrate could possibly have sourced this condition if the prosecutor did not ask for it?
Can I comment?
Yes, please.
Thank you, Chair. Thank you, Commissioners. I'm not too sure where the magistrate could have picked this up from.
Okay.
But when I left I left court before they could pronounce on this bail condition. But before leaving, I spoke to the prosecutor, and it's one of the conditions that I requested, that the crime intelligence officers where the Secret Service account is, that they be prohibited from entering those premises because witnesses, documents that we will require, and documents that we require, and therefore she must, when addressing the court, she must address it. And then I left the court. So I was under the understanding that bail condition, the prosecutor brought it up. And even when I was contacted to say, but this bail condition wasn't implemented, I think it was with General Lushaba. And so, but the main fact of it is that the magistrate, the prosecutor, didn't request for it.
Yes.
I was under the impression she did. Before I left court, I said to her, please. I whispered to her, and then I had to leave court because I had to rush out. But it was never asked from the magistrate.
Yes.
That's
and that's what the High Court found by saying it was never asked for from the magistrate. It wasn't done in open court. It was, but accepting that and you confirming that didn't happen, the next condition becomes more concerning. Did you ask personally the magistrate to impose that condition?
That condition there is, and I think when...
For the record, let's just say, it reads, Mr. Brian Padayajee will assist the accused with the collection of any matters or something, items of personal nature the accused may have on same left at the premises of any crime intelligence officer. The sum effect of it because they are prohibited from entering any crime intelligence facility. Mr. Brian Padayajee, that is yourself, correct?
That's correct, Chair.
Will assist the accused to collect any items they have left in their offices, whether personal or of whatever nature, at these crime intelligence offices. If this condition was never requested, and the magistrate imposed it nonetheless, why does the magistrate pick on you to be the person to collect anything that these accused require? How do we land there? Are you able to shed some light? You say you didn't personally request it from the magistrate. You confirmed that the prosecutor did not put it to the magistrate in open court. Does the magistrate know you personally? Do you know the magistrate personally?
I think it was my affidavit or something, my name was mentioned there. It's a while back, I'm trying to recall. But when I was standing next to the prosecutor, which is quite close to the bench, as the way I can see where he put it there, is I, as the investigating officer, if they want to go to the office, they have to contact me before they go there to their respective offices. So that would have flowed from that bail condition that was set up about the premises. But I left court at that time, and it was only at the later stage that I found that no, this bail condition was put in as they're not allowed. So I, as the investigating officer, that is how the second part, we're looking at 4 Chair Commissioners came in.
So we have a situation where there is a very stringent bail condition that was not requested by the prosecution being imposed.
Yes.
And then it goes further and identifies you personally as the person to assist the accused should they want to retrieve anything from their offices. In circumstances where it was never discussed with the magistrate that is a possible that's a possible solution to the effect of that stringent prohibition. So the magistrate just came up with your name. I'm trying to, and perhaps you don't know the facts, I don't know, but I'm trying to understand how does your name make it into a bail condition that wasn't even requested by the prosecution? Can you shed some light?
A condition that's so stringent that its effect is to suspend the accused. Because what it meant is that they could not go to work. So effectively, it suspended them when SAPS itself had not suspended them. No, but answer the question. I'm just adding to the nature of how stringent it was.
Thank you, Chair. As I indicated, that I spoke to the prosecutor before I left, but during the early deliberations in the court, whilst we're deliberating with bail or whatever, I'm not sure whether anything came up during the deliberations before the bail conditions of not going to the office, etc. As far as I know, is that the prosecutor didn't speak anything about not going to the office, and that is what I heard, because I left there during that moment in time, so I don't know what really happened. But I told the prosecutor, look, those are crime scenes, and I think if I'm not mistaken, and if I can maybe just have a look at one of my notebooks that I was writing whilst I was sitting behind her, that I made a note there on it. But the fact remains of the whole thing is that, from what I gathered, and is that the prosecutor never requested that particular bail condition. How my name came about there is that during the deliberations with the bail or whatever, it's perhaps there where my name came up. It came up during the processes during the course of it. So that's where he probably picked it up from. But I know that the prosecutor didn't mention it. Thank you.
Yes, Commissioner.
Why did you want this bail condition that they must not go to the office? That you say you didn't discuss with the magistrate,
yes,
somehow he comes to know about it. Why did you want that condition?
Yes, Commissioner. As I indicated, we were busy with investigations on the Secret Service Fund, documents, etc. Now,
But this matter had nothing to do with the secret fund. It had absolutely nothing to do with it. This case, this Makwele matter, it was about the recruitment and appointment of Brigadier Makwele.
Yes.
Why are you introducing other cases that under this bail condition?
yes,
Yes, you may.
thank you, Commissioner. I think it was mentioned during the course of the proceedings there that the accused before court are also implicated in other matters that we are investigating.
Yes.
And during that process of not just the Makwele case, but the other cases that we're investigating, I'm digging into my memory that was said there, that we consider the crime intelligence officers, especially where the Secret Service Fund was, as crime scenes.
So you were getting a bail condition, or you were asking for a bail condition that in fact has absolutely nothing to do with the matter that is before this magistrate. It has to do with other cases where you must justify bail, or other bail conditions in other investigations that you are still conducting. You are using this case to get a benefit in respect of other investigations that are not yet complete.
Commissioner.
Yeah, you may
with-
respond.
Chair, Commissioners, it's with the current case before court. The current case was mentioned before court and other cases that we are busy investigating.
No,
So-
you've said you did not want them to go there because that's where the secret fund,
Secret funds, witnesses.
the witnesses, you had completed your investigation and you've seen this judgment. There is an exchange between the prosecutor and the magistrate. And the prosecutor says, our investigation is complete. We don't have a problem about witnesses being intimidated. In fact, we haven't even produced a list of witnesses. So these people, these accused, are no risk or pose no risk to our witnesses in this case. That's the position of this prosecutor, right? The magistrate keeps pushing, but they must be protected. What about members of the public? You know this judgment. I'm not going to read, interesting as it is to read. The magistrate keeps saying, but what about this? What about that? And your prosecutor says, the witnesses, we are not going, if I'm to preclude, if I'm to get an order, that's a condition rather, that says they shouldn't go to the office, then I have to mention the witnesses in this case. And we are not going to mention the witnesses because it would be to endanger them. So there is no risk to witnesses. Investigation is complete. So I don't need this condition, which the magistrate is very keen to give Meromutu without it being asked for, at least not in open court, is keen to give. So your other cases have absolutely nothing to do, even on the magistrate's own enthusiasm. Your other cases are no reason that he has imposed this condition. On this transcript that is quoted in the appeal judgment, those other cases have nothing to do with it. He gave this condition because he's protecting the witnesses in the Makwele matter. My question to you is, why would you want this condition, as you say, you did for cases that have nothing to do with this Makwele matter, that are still incomplete? They are not before court. You don't know whether eventually they will result in prosecution. Is that not another instance of an abuse of your position where you are sitting with this particular case which is done in court?
and that the crime intelligence officers is where it's a crime scene, where all the documents and everything that's going to assist us.
On an
in
investigation that has been completed according to your prosecutor. The investigation has been completed, there is no risk of interference. That's what he tells the court.
Yes.
Yes.
And what happened, I did not know what took place after that, but she didn't ask for it. So that's what happened at the end of the day. I made that suggestion, and then she didn't put it up to the magistrate. So that's where it stands there, Commissioner.
All right. A related question. This appeal was opposed.
Yes,
That's correct.
yes.
What role did you play in the decision to oppose an appeal on a bail condition that you and everyone in Idac didn't ask for? What role in that decision did you play, if any?
We oppose the bail conditions on what I put forward before you now, Commissioner. The fact that the crime intelligence office be busy with investigations, that's
No, I'm not asking for reasons. I'm asking for your role in it. So you were part of the collective that, if it's a collective or it's your decision alone, you were part of a collective that made the decision to oppose this appeal on a bail condition that you did not ask for and that you got because you wanted to protect other investigations, even though that's not why the magistrate gave it. You were part of that collective that made that decision.
I was called part of the collective. I cannot disown the persons that were involved in the appeal process.
And who was involved in it? It's you and?
That would have been myself and the prosecutors that were in the matter that put together documents for the appeal.
Okay. It didn't require approval by your superiors to oppose this bail, this appeal?
Whatever documents that would have been compiled at that moment would have went up to management to look at it further and file it. I'm not too sure whether management did have access into the documents, whatever, but the documents was compiled by the prosecutors and it was filed. There were filings with it.
I guess my question is, where in Idac does the decision lie? Who is the decision maker when an appeal comes up and someone must decide we are opposing or we're not opposing? Who is the decision maker of that?
That will be the head of the office. That
Okay.
will be the head of office, because you cannot take any decisions outside of that.
Okay,
Thank you, Commissioner.
thank you. And I wanted to ask on an unrelated topic.
Indeed, please
Okay,
go ahead, Commissioner.
Okay. The decision to, maybe not the decision, let's talk about the arrest of all these accused. Is there a policy in Idac which guides and informs how you exercise the discretion to arrest, to summon, because we know in some cases you've summoned. The most recent that we can all take judicial notice of is the National Commissioner, right? He was called and he presented to court, but we are also aware of other cases. Here you arrested these 7 accused. Is there a policy, guideline in Idac that informs that guides you as the investigating officer how to go about making that election of how you present or you get an accused person to present to court?
The way I understand you, Chair, Commissioners, is there a policy in how we go about compiling about our arrests in respect of the cases?
It's more specifically with how you get to make the decision whether you are arresting or you're summoning. So I'm not talking about the practicalities of where, how, when do you arrest. Okay. It's not my question. My question is, you have options of how you secure the appearance of an accused person at court, and you know those options that are available to you. So my question is there a a policy position, a protocol, an instruction, whatever it is called, is there an instrument in Idac which informs and guides investigating officers when to arrest, when to summon, when to, I think the other is a warning or something, the different options that you have? Is there such
Yes,
an instrument?
Thank you, Chair, Commissioners. There's no policy or protocol that exists. With regards to the arrest warrants or whether J175, we look at the seriousness. In most cases, if it is Schedule 5, Schedule 6, the onus is on the accused persons to put forward why they should be released on bail. So when it comes
No,
to...
we are not at bail. We are not at bail yet. We are at how do you bring this accused to court? You have options. So the conversation is about you exercising that discretion, because it is a discretion,
Yes.
right? Unless you tell me that, or you tell us that there is a prescript in Idac which says if it is this kind of charge, they must be arrested, right? Unless there is something like that, and you can point us to that. So I'm assuming that in accordance with prevailing law, Idac's position is investigating officers have a discretion depending on the charge. And, well, not depending on the charge. They have a discretion, and you can say depending on what. And is that written, or there's nothing? If there's nothing, and you go about making your selection of the options available to you. So I'm not prescribing to you that there has to be. I'm trying to understand whether there's anything at all.
Yes. What I'm saying here, Commissioner, thank you, Chair,
Yes, you may.
Commissioners, is that there's no particular policy that I know of there. It's when you finish and you're ready and you're prepared to go for your apply for your warrants. You have your chief criminal investigator that's there that says, okay, we're going to now prepare for the arrest, prepare for the takedown. What is the offense? It's a Schedule 5 offense, and we proceed. So, like, for example, I'll give you something out of the normal. When the matters like one of the recent ones was done, and why was it J175? When you look at it, it was the PMFA. So a J175 will be issued. So when as a team that we're sitting together, we look at what is the charges. It's corruption, it's Schedule 5. We have to prepare bail affidavits. So that is where it is taken there. The other considerations, the person is armed, may make away with, intimidate witnesses, et cetera, et cetera. But the basic thing is what I'm saying is, first of all, there's no policy that says this is an office policy. It's a decision taken there by the team, and that's where it is.
So is it irrelevant to the decision that is made by the team that you know where the accused lives? If you know, and let's come back to these facts.
Yes.
You know where General Madondo lives, or you can easily get her information. You actually now have a full docket, so you have her address, you know where she works. Are you saying, well, notwithstanding that I know where to find her and I can serve her with a summons to appear, notwithstanding all of that, all I look at is it's a Schedule 5 offense that I'm charging her with. It follows, I must arrest her. Is that what you're saying? That it doesn't matter that you know that you can bring her to court in a less drastic and less intrusive way than an arrest, because you know her address, her details, and her workplace?
Chair, Commissioners, it's a Schedule 5 offense. Let's put it there. But the way we apply for a J50, it's a warrant, but we don't go to the person's house to execute the warrants. All since I've been at Idac, we phone the person, come to the police station with your legal representative.
We don't go to their homes and place them in handcuffs and blue lights, whatever. The warrant is just there so that we have it, but we call them to the station.
And you place them under arrest at
And
the station?
We place them at an arrest at the police station where they're processed, but it's not something that where we go to the house.
You see, we're going in circles. And maybe I should leave it. You probably have answered as best as you can, and I'll tell you what it is that I'm looking at when I ask this question.
Yes.
We back at, you call them to the police station where you arrest them. My very question is, if you call them to the police station, why do you not give them a summons? Because you know they will appear. The point I'm making to you is, you know their details, you know where they work. You know that if they don't appear, you will find them. Why do you not issue under what circumstances would you not issue a summons in that circumstance, where you know a person's details? And I ask you this because the SAPS has got a policy position about it, and that policy position that has been adopted in a National Instruction 11 of 2019, and it may be that Idac should consider this very seriously, to have something similar. First, this National Instruction, its bedrock is the law, the position of law, right? And what they have done is they say there are various methods by which an accused attendance at a trial may be secured. Oh, I see they've given you a copy. Apparently they've given you a copy. If you go to item 6, it's at page 7. At page 7. Securing the attendance of an accused at the trial by other means than arrest. And one says there are various methods by which an accused attendance at a trial may be secured. Although arrest is one of these methods, it constitutes one of the most drastic infringements of the rights of an individual, and a member should therefore regard it as a last resort. This is what SAPS is saying to its members, not to you. I accept it's not to you. Arrest is never an obligation, irrespective of the offense, but you seem to consider it an obligation when you say, well, in a Schedule 5 offense, I have to arrest. They must come and argue for bail. That's contrary to the SAPS's position and guidance to its members. And then the next paragraph recognizes that it's impossible to lay down hard and fast rules. Each case must be dealt with according to its own merits. A member must always exercise his or her discretion in a proper manner when deciding whether to arrest or not. And then 3, I'll just read the one. It says that a member, even though authorized by law, and you are not saying, I'm mindful that you are not saying, because it's a Schedule 5 charge, the law requires me to arrest. I'm mindful you are not saying that. 3 says, a member, even though authorized by law to arrest, in appropriate circumstances, should always refrain from arresting a person if the attendance of the person may be secured by means of a summons, as provided for in Section 54 of the Criminal Procedure Act. Mindful this is SAPS, why could you not do that with these accused? Why couldn't you, instead of arresting them, why could you not issue them a summons to come and appear? Because remember, there's no law that says because it's a Schedule 5 or even 6, they must be arrested. Why was that not an option that is available to you? Why did you not choose that option and chose the more intrusive and quite punitive way of bringing them to court?
Thank you, Chair, Commissioners. I see the SAPS regulation and the manner in which they do, and each case is decided on its own merits. However, ever since I've been at Idac, with regards to matters that's being investigated, when the matter is serious, it's a serious charge. I know I'm mentioning Schedule 5, the other circumstances with regards to this firearm, witnesses, etc. The normal thing is that we apply for J50s. And as far as I've known, or the operations that I've been involved in myself, is that the J50 that we have is not taken to the person's house and where they're being arrested. They're brought to the station and they are processed there. So all that I can say is that, Commissioner. But then the question will be, why apply for a warrant then? The warrant is there. We have it in case there is something that where the person doesn't report or the person decides he's going to now evade justice or whatever else there is there. Thank you.
Well, I think the correct thing to say, to express how Idac does things, is to say that as a matter of course, we apply for warrants and we arrest them at the police station, because that's what you're saying. We call them to come to the police station, and when they arrive, we arrest them. So your modus is an arrest. We are charging this person, we arrest. That's how Idac operates.
That you are correct.
Okay, thank you. Thank you, Mr.
Thank you, Commissioner Baloyi. Chair and Commissioners, that would bring me to the conclusion of my questions for the witness. I don't know if there.
Colonel,
Chair.
thank you very much. You are excused.
I thought Chair was going to ask me more questions.
We'll resume at 9:30 tomorrow.
Indeed, Chair.
Let's adjourn.
Thank you.